Recently, protests were held by Samsung India workers at Sriperumbudur in Tamil Nadu. The realization of the fundamental right to form a registered trade union to collectively bargain for better terms of employment lies at the heart of the protest. But do workers have such rights to strike or form unions? The Supreme Court in B.R. Singh v. Union of India upheld the right to form associations or unions as a fundamental right under Article 19, Clause 1, Subclause C of the Constitution. The state or the courts could reasonably restrict the formation of unions, associations, cooperative societies, etc. under Article 19, Clause 4 of the Constitution, only if there is danger to public order, morality, sovereignty, or integrity of India. Collective bargaining is defined in Article 2 of the International Labour Organization. Collective Bargaining Convention of 1981 defines it as negotiations between employees and employers or their organizations to determine working conditions and terms of employment. Collective bargaining is statutorily recognized in the Industrial Disputes Act 1947 in India. The right to strike is a legal right recognized with certain restrictions under the Industrial Disputes Act. The Supreme Court described strikes as a form of demonstrations by workers for their rights. For example, they include various forms like go slow, sit in work, work to the rule, absenteeism, etc. The court has observed the right to demonstrate and therefore the right to strike as important weapons in the armory of workers. These rights are recognized by almost all democratic countries. The International Labour Organization considers the right to strike as a corollary of the right to organize. However, the 1947 Act does not recognize the right to strike as absolute. Section 22 of the Act prohibits strikes in breach of contract or without giving employer notice within 6 weeks before striking or within 14 days of giving such notice or before the expiry of the date of strike specified in the notice or during the pendency of proceedings before a conciliation officer and 7 days after the conclusion of such proceedings. This brings us to the end of our video. We hope that you found it informative for your exam preparations. Please click on the like button, share our videos with your friends and subscribe to Exact IAS on YouTube and follow us on Instagram. Thank you for watching this. I will see you in our next.